recording. I'm recording now, and I am going to start muting folks, but people can unmute themselves if they need to.
Okay. Well, then I'm going to kick us off. Good afternoon, everyone. Welcome to I Am Independence Amplified Maryland. My name is Dave Dresner. I'm the Executive Director of the Freedom Center. We are the Center for Independent Living that serves Carroll and Frederick counties. I Am is brought to you by all of your Centers for Independent Living across Maryland. There are 7 of us. A special shout out to the Image Center, Accessible Resources. Katie, I forgot the name of your cell. I'm so embarrassed.
For Independence, it sounds
Thank
like
you.
all the other
Accessible Resources for Independence and Independence Now. Those 3 centers have really done a lot of the heavy lifting since we've started bringing you the I Am shows every week right here, Mondays at 2 p.m. So a special thank you to them. You are all muted now during the presentation. If you have questions, you are free to write them in the chat box. There will be a time we will be pausing, I think, on this presentation to check questions specifically and then move on. So you can unmute yourself if you want to talk. We are being recorded. So I wanted to make sure everyone is aware of that. Also, just a couple other quick announcements before I turn it over. I Am is brought to you every week. There is a separate registration email that goes out every week. So if you've been coming week after week or a few times, you've heard this spiel every week. For those of you that are new, we, as part of the security features, we change the Zoom link on a weekly basis. So you do need to register for each new week. And there have been times when those registration emails or the link with the email with the link to it may end up in your spam folder or your equivalent of a spam folder, your junk folder. So please make sure that you check those on a weekly basis. You can look at any of our Facebook pages. If you go on Facebook or our social media, any of the Centers for Independent Living usually have the link to the registration for I Am throughout the week, so you can find it there. If you miss a show and you want to see them, they are recorded and they are hosted on the Image Center's YouTube page, and the link to go to see the archive shows comes in your registration email, so it's really easy to find down at the bottom. I'm glad that you are all here for today's show. We're going to be hearing about and learning about housing and housing rights, and I think it's going to be a critical topic, especially as we move towards the end of this year, and some of the protections around leasing and eviction potentially end towards the end of the calendar year. So without further ado, if I forgot something, I'm sure Sarah will let me know. I'm going to turn it over to Sarah Basehart, Executive Director for Independence Now.
Good afternoon. Thanks, Dave. I'm Sarah from Independence Now, and I'm going to introduce our speaker today, who is Randi Ames from Disability Rights Maryland. That's Maryland's Protection and Advocacy Agency. And just a few things about Randi so that you know that she joined the Disability Rights Maryland Housing and Community Inclusion team in December of last year. She previously worked at Maryland Legal Aid, where she was the statewide long-term care assistance project staff attorney. And she worked quite frequently on nursing home involuntary discharge cases and access to healthcare coverage and eligibility issues. We still turn to her for that expertise. And her interest in access to healthcare issues began while volunteering, working as a volunteer associate with Maryland Department of Health's Medical Assistance Program. So we're happy to have Randi. I just want to give just a couple more pieces about today's session so that it's clear and you're sure you get your needs met while you're here on our I Am show. Randi's going to talk about 2 topics. First, she's going to talk about reasonable accommodations, and tenants is all under tenants' rights. But if you have questions while Randy's talking about that and you want to be sure you don't lose that question, you're welcome to put it in the chat. I'll be monitoring that during our hour together today. And then I'll be sure those questions get to Randy when she takes a pause in the middle. Sort of, we have two very different subjects today with reasonable accommodations and then evictions. So we'll cover reasonable accommodations first, take a pause, take questions. If you need to ask or prefer to ask your question verbally, you can raise your hand by hitting at the bottom of the screen under the reactions. You can raise your hand, or sorry, under the participant, you can raise your hand, or you can just stick it in the chat and I'll be happy to read it for you. And then we'll move on to the eviction portion and again, take questions at the end. At the very end, we'll have time for community announcements. So if you have any of those, I know Crosby already punched in that he has one, so we're happy to take that up at the end of our session and any other community announcements. So Randy, would you like to kick us off?
Yeah, I just want to make sure everyone can hear me okay? Great. So I'm going to be sharing my screen. I have a PowerPoint presentation today. So just give me one moment. Okay, so can everyone see my screen? Great. So as Sarah introduced me, I'm a staff attorney with the Housing and Community Inclusion Unit at Disability Rights Maryland. Make sure. And DRM, Disability Rights Maryland, formerly known as the Maryland Disability Law Center, as was mentioned, we're the designated protection advocacy organization for the state of Maryland. So, you know, we touch on a lot of different legal issues, but just to highlight a few, we'll go over our housing unit enforces fair housing rights. We have a focus on protecting against abuse and neglect in facilities for youth and disabled adults. And our work touches on special education issues, transportation, voting advocacy, Medicaid issues, and Social Security benefits. So just to kind of give a little roadmap for our training, because we're going to be covering a lot of information today. So we'll start with reasonable accommodations. As Sarah mentioned, we'll take a pause and answer any questions related to reasonable accommodations. And then we're going to go over an overview just generally of Maryland's eviction laws and how the CDC eviction moratorium and the governor's order relate to those the eviction laws. So let's get started. So this is just a general overview of the framework of the state and federal laws that govern reasonable accommodations. So the Federal Fair Housing Act will go into more detail, but that's really the big umbrella federal protection for different sorts of housing. And we'll go over the different sorts of housing that each law applies to. And then the other big federal one is Section 504 of the Rehabilitation Act, which applies to any housing that receives federal funding. And we'll also touch on the ADA. So generally speaking, you know, just kind of the big picture, the focus is on reasonable accommodations, but just generally a property cannot refuse to sell or rent, make housing available, or just discriminate in general terms due to a person's disability. And that includes refusing to make a reasonable accommodation. So the Fair Housing Act, again, we'll go into a little more specifics, but applies to most housing, and that's extended to HOAs. And again, it prohibits against the discrimination in accessing housing. So the purpose of a reasonable accommodation is to ensure that someone has housing that's accessible. So the protections of the Fair Housing Act also extend further that a housing provider has the duty to provide, requires affirmative action in providing opportunities for accommodations. So there are some exemptions where the Fair Housing Act does not apply. Single family homes, for instance, if I just decided that I wanted to start renting out my home and I was gonna go move somewhere else, the Fair Housing Act wouldn't apply to me, that I would have to, provide a reasonable accommodation. However, if I used a real estate broker, really the impression that this is a business entity, or a professional housing that's being rented out, then the Fair Housing Act would apply. Similarly, if I may own my home, but if I own 4 single-family homes, doesn't matter if I don't rent out 2 of them. If I own 4 or more properties, single-family homes, then the Fair Housing Act would apply. So these are just kind of some general exemptions. Another big one is senior housing, either 62 or older or 55 and older. So for 55 and older, that a property is only required to have an 80% of that property be for individuals 55 and older. That other 20% could be to younger people. So just kind of going over the definition of who is a person with a disability. So it doesn't require a determination from the Social Security Administration. Really, it's a very broad definition that's really just supposed to touch on any condition that may impact or limit a major life activity. And again, or under the regulations, a landlord cannot require disclosure of a specific condition or symptoms. Rather, the intent of having to notify, it's supposed to be a broad, just notifying your landlord that you're a person with a disability, and how that disability connects to your needed accommodation. So reasonable accommodations, it's when a tenant is asking for a change in the rules, policies, or practices of a property. And they could be pretty broad, and we'll go over some kind of general examples. And the right to a reasonable accommodation starts from the application process all the way to an eviction. So we'll also go through a few examples of what that may look like, kind of from soup and nuts. So under the fair housing or reasonable accommodation laws, again, a qualified disabled person can request a reasonable accommodation, and to ensure that opportunity to using the property. So some examples are permitting a tenant, changing how a tenant is able to pay rent, how a prospective tenant. Again, it's really just showing the connection to the disability, that there's a disability, and what the accommodation is needed, what accommodation is needed. So for a reasonable accommodation, the landlord is liable for the reasonable cost of that accommodation. So a common example is a request for a parking space. So if there are costs associated with reserving a space, such as putting up a sign or restriping, a landlord would be liable for those costs. And I found that a lot of times, if it's an accommodation, such as grab bars or low cost items, a lot of properties are willing to provide those. It really just depends on the property. So for a reasonable accommodation request, in order to deny that request, the housing provider must show that the accommodation would create an undue financial and administrative burden. So they have to show both, that it would be a burden both financially and administratively. So related to accommodation requests, reasonable accommodation requests are reasonable modification requests. So a tenant can request a modification, but under the Fair Housing Act, that tenant would be responsible for the costs. So the same legal protections to request that modification apply, and for a landlord to allow for that modification. However, under the Fair Housing Act, who pays for that is typically on the tenant. Again, there are sometimes situations where a landlord may be willing to work with a tenant for lower cost items, but generally the modification would be out of pocket for the tenant. So what we just discussed. Again, the costs. And I apologize. Give me one moment. I'm just trying to. Let's see if I can. Just having one problem with seeing my screen. Let's see if I can. There we go. So, you know, if the development was already required to have an accessible feature, obviously that would be where the property would be required to pay for a modification. And HUD has given guidance that tenants may be responsible for restoring the apartment to its original state when they move out, but only if the modification would impact the marketability of the unit. So going on, you know, kind of some general modifications where restoration would not be required is things like widening doorways, installing grab bars, and installing accessible routes to sidewalks. So reasonable accommodations and reasonable modifications can both be requests related to an individual unit as well as common areas at a property. So again, a landlord in reviewing an accommodation request, you know, if there's going to be significant modifications to the physical layout of a unit or the property, can require, you know, plans to see that, you know, to be notified of who you're working with as a contractor, ensure that they're licensed, things like that, to ensure the safety of the project. So, again, just some general examples of modification requests may be to allow for a ramp, grab bars, lever doors, specialized alarms, lowered mailboxes, and lowered light switches. And where a landlord is not required to pay for a modification or is unwilling to, there are sources to seek for funding for modifications. Participants with the Community First Choice program, as well as the Home and Community-Based Option Waiver, are eligible for home modifications as part of that benefit. Under the Medicaid program, there is a $15,000 cap to modifications, and those funds, that $15,000 cap goes for 3 years. So at the end of 3 years from the time of payment, a participant can become re-eligible for more modifications. Similarly, there's local programs and grant programs, which I know CILs are familiar with, and that's why it's always great to, you know, see on a county level what programs may be available for assistance with paying for modifications, as well as for tenant-based voucher participants. Public housing authorities, some public housing authorities have modification funds. For instance, in Prince George's County, as well as Baltimore County, there are modification programs that tenant-based voucher participants can request assistance with paying for modifications. So again, or kind of going on to the nature of alterations, again, a reasonable accommodation cannot alter the fundamental purpose of a property and cannot create an undue burden. And the determination of whether something is a burden, a financial burden, is an individualized review. So, and a defense can be made. You know, part of the purpose of a reasonable accommodation request in reviewing it is a landlord does have the obligation to do to have an interactive dialogue with a tenant to see if there can be some resolution. So in Maryland, the state law, the Maryland Fair Housing Act, it follows the federal Fair Housing Act pretty closely, but adds additional protected classes. Next, Section 504 of the Rehabilitation Act. This applies to properties that receive federal funding. So any properties owned by your local public housing authority, properties that are subsidized by HUD directly. And here's just an overview. But again, the exception, with an exception of tenant-based voucher participants, simply because a property accepts a voucher, that does not expand this obligation to the entire property, similar with the Fair Housing Act. Okay, so under Section 504, there are particular accessibility requirements with new construction, in particular that 5% of the units be UFAS accessible. Those are the Uniform Federal Accessibility Standards. And similarly, and furthermore, under 405, modifications, further modifications would be paid by the property. So under Section 504, here are some more examples of modifications that may be an undue financial and administrative burden, such as walk-in showers, and program changes that are outside the main business of the property. So as I mentioned before, property managers and landlords have a duty to take part in an interactive process. This is to discuss alternatives or barriers or ways to work around, or to discuss if a property is unwilling to approve a reasonable accommodation request as initially requested. So that may be modifying that request and looking and discussing alternatives. So under the ADA, Title II and Title III cover properties. So these are under Title II, state and local government properties that are owned by the state and local government. This extends the requirements under Section 504. And the purpose is it requires that people with disabilities have the equal opportunity to participate and receive equal benefits of government goods, services, and programs, so accessing state and local buildings. So this does not, under the ADA, Title II does not explicitly extend to housing. However, open to the public areas under Title III. So things like leasing offices, swimming pools, areas that should be accessible to residents. So enforcing your rights under the ADA in Maryland, the entity we refer or assist people with filing complaints to is the Maryland Commission on Civil Rights, HUD, as well as the Department of Justice and the Attorney General. So here's some tips in figuring out whether a development is federally subsidized. Looking at the rent amount, is it based on income? Is there a subsidy involved directly from HUD? The National Housing Preservation Database is an easy resource to see if a property receives any, community development block grants or other funding. Or you can simply, sometimes if you ask a property, they may not know, depending on who you're speaking to. But typically, as part of the lease, there would be an additional addendum that discusses your rights since the property receives federal funding. So as I started with a reasonable accommodation, you have that right from the application ending, a subsidy terminating, or even an eviction. So common barriers to accessing housing, things like missing IDs, not having social security cards, you know, not having a credit history, things like that. So these are kind of just some big picture barriers to the process of accessing housing. And a reasonable accommodation request can be submitted to address some of these barriers. So in the application process, may be for alternative print sizes or formats of applications, assistance with completing an application, you know, allowing it to be mailed or faxed rather than submitting online or having to come in person. So really it's just getting that your initial foot in the door and applying for housing that even before you move in, a prospective tenant has rights to an accommodation to assist with the application process. Another issue with credit issues, again, this may be related to medical bills, loss of employment, the inability to access treatment for disability, all of those issues. Those kind of screening issues, a property should allow for a reasonable accommodation request, for instance, overlooking credit issues related to disability-related medical expenses. Again, the goal is to tie the request and the person's disability to clearly show why to support the need for the accommodation. Another area that we get a lot of cases on, and I want to touch on, are service and assistance animals. They are protected under the Fair Housing Act, and emotional assistance animals and service animals should not be treated differently. You know, they can be any type of animal. They can go anywhere the tenant can go, but they must be under the tenant's control at all times. Oh, and going back to service and assistant animals, you know, in approving a reasonable accommodation for service and assistant animals, they should not be treated as pets. So pet policies, pet fees, pet rent, pet deposits should not be charged. Exceptions to assistance animals, you know, if a property finds that the animal poses a direct threat to others, if a resident is unable to keep that animal under control, you know, that would be reasons to find a different animal, so that the reasonable accommodation for the assistance animal is still approved. It just may be seeking a different animal, or trying to mitigate that with additional training, or, you know, just communicating that issue. But if a property has concerns about an assistance animal, they need to provide proper notice. Another area that we do a lot of work in with reasonable accommodations is for an additional bedroom. So this may be someone who has a housing choice voucher for one bedroom as a single person, but they need an additional bedroom, maybe for a live-in aid, medical equipment, just to, you know, again, allow for that person the opportunity to continue living independently with their voucher. So it's inappropriate for a property to assert that a resident is unable to live independently because of their disability. If there's concerns about safety concerns, it needs to be individualized and supported by facts. So simply saying, because you're a person with a disability, you can't live alone, that's discrimination and inappropriate. So furthermore, properties cannot require, you know, family members to sign off on a lease with a person with a disability due to that disability. They can't allow a family member to terminate the lease on the individual path due to their disability. And again, they should treat documents like powers of attorney and advance directives appropriately. That does not. Those do not give a representative the authority to terminate a lease. So reasonable accommodations can provide for an early termination of a lease. If due to somebody's disability, they may need to request that they end their lease early, and that's provided under there's a specific regulation under Maryland Real Property 8-2122.2. So another issue is possibly somebody who's dealing with mental condition that if, say that person's not receiving care or in treatment or is in the process of starting treatment, but if they have, or, just due to the nature of their disability, they have behavioral issues, as long as they're not a danger to the health and safety of others, a reasonable accommodation request can be submitted on their behalf to address that, kind of acknowledge that the person has a disability, and kind of what is feasible, and also possibly develop a plan of action. So now we're going to talk about kind of the nuts and bolts of submitting a reasonable accommodation request. Again, this can be a reasonable accommodation request can be submitted at any time, and it should be submitted to any person employed by the housing provider. So the property manager, maintenance, anyone in the leasing office, and it can be submitted by the person with a disability or somebody on their behalf, such as a family or friend or a healthcare provider. A reasonable accommodation request can be submitted verbally, but we always recommend that the best practice is to do it in writing, something that's dated and signed, and then copy. Again, we, if possible, emailing to follow up if you want to if somebody wants to drop off a physical copy, but just so you have that record to track. And here's a sample letter. We can send this out later if anyone is interested, but just generally, kind of making sure that it's clear. Again, a person is not required to give their specific diagnosis. And again, just identifying themselves as a person with a disability and specifying as particularly as possible what they're requesting and why. So a housing provider, may ask for documentation to support that the person is in fact a person with a disability when that disability is not readily obvious. That supporting documentation can come from a healthcare provider, but it can also come from a case manager or social worker, really any reliable third party that has direct knowledge of the person's disability can provide supporting documentation. And again, that supporting medical documentation does not have to come in a specific form. And again, they should not be required to disclose the specifics of their disability. So once a reasonable accommodation request is submitted, a housing provider has a responsibility to respond in a reasonable amount of time. Unfortunately, the law does not give a specific deadline for housing providers to respond, but depending, and it's really specific to the nature of the accommodation sometimes, whether there's questions of feasibility, whether there's an interactive process that needs to occur. But once the request is approved, there should be a time frame given, and should be in writing. And if the housing provider is proposing alternatives, they should document that and explain why. If the request is denied, a housing provider must give the reason for the denial. Again, they must engage in that interactive process, And you know, if the denial is based on financial burden, they need to explore, you know, what portion of the work could be done and explore alternatives to funding. And a reasonable accommodation can be used to prevent evictions, kind of what we were touching on a little bit before. But, you know, if there's a reason that someone is, one example that comes up a lot is a person may need a reasonable accommodation to pay their rent after the 5th of the month. Typically, a lease requires that rent be paid by the 5th. However, if they receive a particular financial benefit from the state or federal government, or from, you know, if they're retired and their benefit check comes after the 5th, they may need extra days to actually, you know, get their check, process it, and be able to pay. So, you know, or another example is an unauthorized occupant. Well, if the unauthorized occupant is actually really that person's aide that they rely on for assistance with care, you know, there's a process for requesting a live-in aid. So we'll take we'll stop right there and go over questions related to reasonable accommodations.
Great. Thank you, Randy. So much good information there. I have to hear this kind of stuff over and over again to get it into my brain, so I'm sure it's helpful for everyone. So the first question is about, and Shafan, I'm going to hope that I get this right. I'm sort of going to summarize, but she's looking to ask a question about if you as a renter, you know, pay for an accommodation, modification to be done in your apartment, can you either like get a tax write-off, you know, for those funds that you're using to pay for that modification, or if you decide to move later and you're permitted to leave the modification, do you get a portion of your rent back because you've, you know, paid for that modification that we all think of as enhancing, you know, living spaces, right? So I'm going to stop there.
Yeah. So I am not familiar with any right to receive, you know, a portion of the cost back. You know, if it's related to medical costs, you know, I am not a tax attorney, but at the end of the year, you know, I would, you know, speak to if you get your taxes done by one of the available programs, that you paid a significant out-of-pocket cost for something related to medical equipment, to see if there can be some kind of deduction, but I'm not familiar with that off the top of my head. It's not something that we typically assist with.
Thank you. The next question is about what requirements will be required. I think maybe the accommodations will be required for new buildings for the deaf-blind community.
You know, under the Fair Housing Act, new buildings are required to provide at least 5% of buildings that are that have accessible features, 2% of that having accessible features for blind and low vision residents. So as are being built, and depending on the funding, especially if it's federal funding, there are requirements for certain percentages of the building to have units with accessible features. But if it's a covered property, the request can be made to, so if you're in a unit that doesn't already have those accessible features, you can make that a request. You know, so say a unit with those accessible features are not available, and the property may be willing to cover the cost depending on the nature of the modification that's needed.
Do you know specifically to the deaf-blind community what those features are? That's
Yes.
what the person's asking.
Oh, I apologize. So things like alternative alarm systems, you know, sorry, I'm blanking off the top of my head now. I'm sorry.
Sometimes there's different doorbells and microwaves,
yeah.
that kind of thing. Okay. That's all. Any other questions I can't tell if anybody has their hand up. I'm going to ask for Heather to help me spot that. Oh, sorry. Oh, sorry, two more. Will there be any looping, for the hearing for people that use the T-loop, it's called, right? For hearing purposes. Do you know if that's going to be added into any new buildings? I guess maybe more broadly, the question is, are there new features for the deafblind community that are being added? I haven't heard that, but you're the lawyer.
Yeah, that's what I was to say. The uniform, the federal uniform accessibility standards, there haven't been any recent updates that I'm aware of for new features.
Okay, thank you. And then the next person is asking, could you clarify if a property owner is shutting down a property, can a tenant request a reasonable accommodation to stay or time enough to search for a new place? What should they do? Certainly can be harder to find accessible units, if you need to move from somewhere. I'm assuming that's where the question's going.
Okay. And just to ask, is this, it was like public housing or a property that has federal funding, or just like a private building?
So Melissa, we'll need you to tell us that. Is this for a property that's private? It's a private property.
Okay. So for that situation, a property is required to give you the same notice as an early lease termination. So that would be 30 days and 60 days in the city. So again, if depending on, that would be very fact specific, but depending on what the timeline is for demoing the building, there could be it could be reasonable to request an accommodation. That would really fall on to whether it's an undue financial or administrative burden, depending on what the plan for demolition is. And I'll just touch on the reason I was asking for public housing or housing that receives federal funding. There are much more strict regulations requiring 90 days notice of a plan, and then supports in assisting residents of public housing or subsidized housing, making a plan and providing alternatives for subsidized housing at other properties, and the right to return if the property is, being demoed to be replaced with new mixed funding, a mixed rent or mixed use property, which is happening a lot in the city right now with Perkins and other properties where public housing authorities are demoing older buildings.
Okay, one more question. And this is more about vouchers than, say, reasonable accommodations exactly, but for a county-based voucher program, if no accessible, I actually know the answer to this, but I'm gonna let Randy answer. If no accessible housing is available in that county, is the person allowed to take the voucher out of the county, or do they just remain on the waiting lists?
So Sarah, but yes, you can transfer the voucher, but if you want to have anything else to.
Well, we've had consumers who have done that in Prince George's County that their name came up, and this is Joan from ARI asking, that have come up on the voucher waiting list and were not able to find accessible housing and ported that voucher before, ever having actually used it in the county. So it is possible. Okay, we're going to have Randy move on because we are going to run out of time. So yeah. Randy, we have about, a little under 15 minutes to cover evictions. I'm not sure if that's possible, but go for it.
Yeah, kind of the big picture of eviction, and then touch on the eviction moratorium. So just evictions generally in Maryland. So a landlord cannot do a non-judicial eviction. It's essentially an illegal eviction where lockout, there's a specific code under the real property section that prohibits that. So a landlord can only evict a tenant with an order from a judge, and the sheriff must execute that order. So there are three limited reasons why a landlord may evict a tenant. That's a breach of a lease, the lease is ending, and then that that's known as a tenant holding over action, or because a tenant hasn't paid rent, a failure to pay rent claim. So breach of lease, the requirements are that the landlord provide 30 days or 14 days if there's an imminent threat to that they're accusing a tenant of an imminent danger to the health and safety of others. And then if the tenant does not vacate based on that notice, then the landlord must file a complaint. And before a court, the landlord would have to show that there was in fact a breach, that it was substantial, and that it raises to the level that it warrants eviction. So tenant holding over, this is more tricky, where for private housing, a landlord can simply decide, I no longer want to rent to you when your lease is renewed, or when it's time for your lease to renew. Throughout the state, it's typically 30 days notice, but in Baltimore City and Montgomery County, a landlord is required to give 60 days notice. Again, if the tenant remains, then the landlord would have to file a complaint, and then their burden would just be to show that there was a lease that expired, and that the tenant remained in the unit after notice was provided. And lastly, failure to pay rent. These are harder in the sense that they move much faster to the court because there's no pre-filing notice requirement. So once you're past, typically it's your rent's due the 5th of the month. Once you pass the 5th of the month, your landlord can file for an eviction and start that process. And they, prior to the pandemic, they would get scheduled fairly quickly. So again, for an eviction to take place, landlord has to receive a judgment. A tenant has 4 days to appeal that eviction. After the 4th day, the landlord can request a warrant of restitution. That's the order or the warrant that a sheriff serves. And in Baltimore City, the sheriff must provide a 14-day notice prior to the eviction. So to a lot of people's delight, back in September, the CDC issued this national eviction moratorium order. So what the order does is that it temporarily halts residential evictions for covered persons for non-payment of rent through the end of 2020. So, excuse me, the order extends there really any property where there is a landlord-tenant relationship anywhere within the U.S. or its territory. So it's a very broad order that provides a lot of protections. However, we're going to talk about some of the nuances and issues that are coming up. So who is a covered person? So the CDC came up with a declaration form. I provide the link. A simple Google search, you can find this form. And again, a covered person is pretty broad, but it's any tenant of a residential property. But what's required is that they declare these 5 terms that are listed under the penalty of perjury. So that the person has sought any rental assistance that they make under a certain amount of money, that they expect to make under a certain amount of money in the calendar year, depending on whether they're filing, they would be filing their taxes as an individual or filing jointly. That the individual is unable to pay the full rent, and that they're making the best efforts to do so, and that eviction would likely render the individual homeless or force the individual to move into and live in close quarters in a new congregate or shared setting. So this is the one a lot of our clients are having issues with. Some of them say, oh, well, I would find something that's cheaper or something I can afford, or while the intent is good, some of the terms can kind of narrow down who this protection applies to. But the form requires that the person declare under perjury all 5 statements are correct. This form should be submitted to the property owner landlord, and this can be done preemptively. So if someone is having difficulty paying their rent today, they don't need to wait until a failure to pay rent claim is brought against them. They should file this form with their landlord as soon as possible. So under this order, however, people can still be evicted. So, you know, engaging in criminal activity, threatening the health and safety of other residents, damaging or posing an immediate risk. The issue, so part of the issue with the CDC moratorium is really it's being applied to failure to pay rent claims and breach of lease claims for failing to pay rent. However, some courts are not extending it to tenant holdover. So especially given the length of the pandemic that's gone on, somebody's, you know, they may be month to month, or it may just be that their lease is coming to an end. So while they may not have been paying rent this whole time, and really they're being evicted because they haven't paid rent, a landlord can file a tenant holding over saying your lease is over with. You know, this is not a failure to pay rent, this is a tenant holdover. So unfortunately in Maryland right now, even though there has been some guidelines from the courts are really enforcing this protection differently. So it's really, attorneys throughout the state are still trying to figure out the best way to advocate for the reason for eviction is based on a tenant holdover, and even under the order, some courts are issuing an eviction order but staying it through the end of the year. So essentially, you know, after January 1 or the next, you know, business day, that landlord can go and say, okay, you know, I want to warrant a restitution now. Where other courts and other judges are saying, no, this matter needs to be held and we'll come back after the moratorium for me to enter a judgment. So right now, it really depends on the court and the judge you're before. So the governor had an eviction order previously that he extended on October 16. And what that order does is it's different than the CDC moratorium and provides different rights, but it's similar. So, however, the eviction moratorium under the governor's order extends through the state of emergency. So, if the pandemic, which seems likely, goes past December 31st, this eviction order is still in place. And it relates to failure to pay rent claims and breach of lease claims, and where this is a defense based on the person having a substantial loss of income, and it doesn't have the same requirements as the CDC declaration. So another protection I just want to highlight under executive order, under Governor Hogan's order, is that a confirmed case of COVID-19 of a tenant or possible cohabitant is not does not constitute clear and imminent danger for a breach of lease claim. So your landlord cannot say, hey, you know, you have COVID, we have reason, or we know that you have COVID-19, that's a breach of your lease, that's impermissible. So one thing I just want to touch on that's not related to evictions is effective October 1st, the Housing Opportunities Made Equal, the HOME Act. And this is a great protection in allowing for participants of the Housing Choice Voucher Program to no longer, landlords can no longer discriminate on the source of income. So whether it's through grants or some other financial assistance, a landlord cannot discriminate on the source of an income that a person has to pay their rent. Yay. So there can no longer be restrictions on or discriminate against voucher participants. And then last, I just want to highlight, these are the programs throughout the state for legal assistance. You know, these, especially with the CDC moratorium and the governor's order, these are complex. And if someone's facing an eviction, you know, as early as possible, contacting one of these agencies for assistance. So questions related to evictions?
I have sort of an off the wall or another side of the coin question. I know there are a lot of landlords out there who have maybe one or two properties and they just rent the house out to pay the mortgage on the house, etc. I used to have a place like that. Is there help for landlords who maybe they're keeping a tenant in, but they can't really afford to go without rent? Or do you know?
So in Maryland right now, there's a couple of different things that property owners can do. One, there are some similar to rental assistance programs. There are some homeowner programs that have been established that are county specific, but also with the governor's order, there is a moratorium on foreclosures. With the previous CARES Act and other direction for mortgage lenders to provide for extensions and relief in mortgage payments. So,
Gotcha.
yeah.
Well, and congratulations to the work of all the housing organizations for getting the Home Act passed. I know the Sills worked on it. It was a many-year activity. I think it was being worked on when I first came to Maryland 20 years ago. But congratulations to everyone. Finally, we have a Home Act, so we have protection against source of income discrimination.
You to go back in your slides to the slide that listed all the resources. Thank you. Someone's asking for that, and I think that if we leave it there, maybe while we take final questions, or for a couple minutes, so people can jot those down. And then I don't know, Heather, maybe we can post that as well or send it.
PowerPoint for the list.
Yes, thank you. Are there other questions about evictions? I think there weren't any posted yet.
I know I was trying to go fast. I didn't want to go too far over time.
Yeah, I know. We have, it's already 3:01. But I know people often, have other things they have to go to. But if nobody has any questions, thank you so much, Randy. This is excellent information. And Heather, did you say that we would distribute this?
If Randy can send me the PowerPoint, I can certainly do that.
It's hard to believe that anyone could have anything more important than these meetings, but are you sure? Okay.
Well, that is true. But and thank you, Randy. That we appreciate that, because that also helps the Sills, and that we can also make sure our staff have it in case they weren't able to be on. But I guess then. I'm sorry.
Oh, I was just going to say, and also I'm always happy to be a resource or a connection. If somebody has a general question or questions on how to complete an intake with DRM or, other resources, either through Sarah or, contacting me directly. I'm always happy to help.
Thank you. Okay, so if there's no other questions, I guess I'll let Dave, and then I think Katie close things out, and Crosby's the first one with community announcements.
Yeah.
Thank you, Randy.
Thank you, Randy. Hi, it's Dave again. I know we're really up against the clock, and I want to make sure Crosby has time, and Katie also, to talk about next week. So I'm just going to say thank you to everyone, and Crosby, if you can unmute, we'll turn it over to you.
Okay, I have a question and a announcement about voting, but first I've got a woman in Parkville got a hold of me, and she needs a ramp. I don't know if one of the Sills can help with that, or any of y'all really. She wants she needs a concrete ramp that's ADA accessible, and she said 1 to 2 steps. So that's probably maybe.
Send her to me.
Can to you, Mike?
Yeah, send her over to me. I'll get her to the right person. Stephanie Taylor's our person who works on that, and we can take a look at the situation, see if we can help.
Thank you, I will.
Sure.
The other thing is about voting, which I didn't think about talking about, what was it, 2 or 3 weeks ago when Ben was here talking about voting. So I just want to add my 2 cents in that. Most of you know this already, but voting in Maryland is really important, of course, coming up in a week and 1 day. But even more important is voting on midterm elections in Maryland, because in Maryland, those elections they happen every 4 years, and they're spaced in between the presidential elections. So the next one would be in 2022, and then 2026, 2030. I'll probably be dead by then, 2034. And they're important because just about all the statewide offices are filled on these midterm elections. So we've got the governor, all the state senators, and all the state delegates, and I imagine a lot of other offices as well. So yes, in 8 days you need to all vote, but keep in your mind to remember to vote and tell your friends to vote in 2 years. And that's it.
Great.
Excellent. Thank you.
Oh, I'm
Go ahead,
sorry.
Katie. Yep, jump in there.
I just
You're up.
wanted to let everyone know about next week's session. For those of you who are interested in transit, you'll want to attend next week's session. We're going to have Jade Clayton and Jamie McKay from the Maryland Transit Administration. The Maryland Transit Administration has been tasked on putting together a 50-year transit plan, and it's a statewide plan. So it'll include all areas of the state, not just the area that MTA kind of serves. So it's really important for you to be on the call to learn about the plan, and also to make sure that if you have comments or suggestions on ways in which Maryland can improve transit, particularly for people with disabilities, you'll want to be sure to provide input.
And
So
there
don't
are
miss next week.
disability-related issues in that plan, and there are also things about these new floating bus stops apparently that are in the plan. So if you have issues, how do people get a copy of that?
I don't know. I don't think they have there's no plan yet.
No plan yet. They're just taking input.
Yeah.
Okay. Gotcha.
Yeah, they're developing the plan.
All right.
So just getting input now.
Yeah, the survey just ended on Sunday.
The
So
input
it's-
survey? Okay, gotcha.
Yeah, because MTA has really been trying to get input from the beginning prior to coming up with a plan, so that people can really be engaged at the get-go and not just once a plan has, been presented. So make sure
Well,
you
I
join.
particularly like the idea of a longer plan, a long-term plan. When I was in Oregon, I used to be able to look at a 30 and a 40-year plan when I was looking at where I might want to move to, as far as whether there was going to be continued emphasis on buses there, et cetera. There's nothing worse here in Baltimore than to move to a house. I know some people who do it, and then they discover, oh yeah, I'm in this house, but the city's going to take away my bus. So longer planning is really helpful for people who are deciding where to live so they can use transit.
Good stuff.
Yep.
Okay.
Enjoy.
One last thing before you go, I just want to remind everyone that I Am is brought to you by and for persons with disabilities. And we are always looking for feedback and input from all of you, the people who sign in every week, to listen on what are the topics that you want to learn more about or discuss more about. So please reach out to us. Right now, there's still, I think, 5 of the 7 CILs, their directors are on video. So no matter where you live in Maryland, there's a Center for Independent Living that serves your area. And if you don't know which one it is, call anyone and we will get you connected, and reach back out to us and let us know what you'd like to hear about on I Am. Thank you, everyone,
Yeah, send any program ideas to info@imagemd.org. We would be glad to take a look at them. We really want to keep this program going, but we want to do it with your input so that we're putting the kind of things on that you want to hear about.
Excellent. And with that, thank you, everyone, and have a great rest of your day.
Have a great day, everybody.
Bye.
Enjoy.